Hi, welcome back to SouFLoTV again, everybody. It is your host with the most. Just go ahead and hit that subscribe button, please. And let's get right into this. So, we've been following the Clansman One Dan Gang situation story. And like I said before, this case is being tried behind closed doors. So, we don't have a camera behind the scenes. And we have to rely on information that is given to the public through news entities. So, we're taking this one from the Jamaica Observer today. Details about what went down in court as Chief Justice Sykes handed down the first guilty verdict in the case. Alright, so Chief Justice Sykes on Wednesday dismissed as absolute nonsense and total rubbish arguments by defense for the Clansman gang accused Roel Taylor that he could not have been the owner of a gun and ammunition that was found by police in the furniture shop he operates because there were multiple other entrances which made the premises accessible to other people. This is what Roel Taylor's defense attorney said. They said, listen, he owns the business, yes, but anybody could have placed that rifle inside of the business because that area where you found it was open area and a lot of people had access to that area. The judge said absolute nonsense, total rubbish. You should know a guilty verdict was coming after that. Anytime your defense attorney gets told by the judge that the theory they just came with to try to defend you is absolute nonsense and total rubbish, just know Sayago found guilty after that, right? Okay, so according to the trial judge who declared Taylor guilty on one count of illegal possession of firearm and one count of illegal possession of ammunition, the fact that Taylor had in his possession a key to the shop, which was what was used by the cops to access and search the premises, that made shambles of the defense. So is the key that Taylor had was used to access the property. That means to the judge that the property was under lock and key and they couldn't get in any other way until they got the key from Taylor. So this thing that his attorneys are saying anybody else could have put it there, rubbish. Taylor, who is among 26 alleged members of the St. Catherine-based Clansman gang on trial for several crimes since 2021, had denied knowing of the presence of the rifle. The rifle, by the way, is an AK-47, which was discovered along with 10 rounds of ammunition in the shop, all of which were entered as evidence during the trial. Now, Taylor had claimed that he had not been to the furniture shop and he had not taken the police to the furniture shop when they conducted their search after searching his home in 2019. A witness who took the stand on his behalf had, however, said that he was in fact taken by the police to the shop. The accused, however, maintained that the cops had come back to him at the house asking him for his keys to the shop as his uncle who said they found there. That was his uncle who they said they found there, claimed that he could not find his set of keys. The police had left. The police left, they left him, and he said that they didn't. He said they asked for his keys and they left him in the house. Then some 15 minutes later they came back and took him to the shop. Now see what that would mean. You have to walk with this, you know. I know it's long and I know it's a he said, she said, and I know it's rowny, but walk with it, right? If you really want to understand the case. So his defense now, Taylor's defense is that the police came to his house, took his key to the shop, went to the shop. He didn't go with them. the first time and they didn't take him. They took the keys, they went to the shop. They came back for him 15 minutes later and took him to the shop. And then when they took him to the shop, when they came back, is when the gun was found. If you have any sense, that would simply tell you right there. So they took the keys, went to the shop, planted the evidence, which was the AK-47, came back 15 minutes later, got him from the house, took him to the shop, and then start searching the place and pull up the AK-47 in front of him and ask him, what this a do, yes, a big man? What this doing here, sir? And he's looking at them like, I don't know. Now, that's his words against the police words. The police said that's not how it went. We didn't take his shop keys and go to the shop without him. He was right there when we were doing the search. It was his keys that we used to enter the shop, and he was right there. What seems to be common is that there is a key to access the shop. The unsworn statement by Taylor does not assist us with why the police would need the key, why the police are preoccupied with a key. The trial judge says, pointing out that the witness for Taylor did not mention the key in her account either. Her point is that there was open access to the workshop. That is literally the essence of the contest between the prosecution and defense. The police witness said he did not see an alternative entrance and the lock was opened by the key. So for me, I do not accept that the shop had multiple entrances. Whether it's 5 or 1, it doesn't matter, Justice Sykes said. So I'm going to get the point now. They were trying to argue that there was multiple ways they could have gotten into the shop, and Justice Sykes is saying apparently not. Then the judge said, I accept that the police went to the property, and I'm satisfied so that I feel sure that the room that was identified by Mr. Taylor was occupied by him and relatives. I am satisfied that the room was searched and the keys were found by the police. I accept that there was a key to open the lumber shop, and I am satisfied he took Mr. Taylor over to the shop, and legally, even if they didn't take Mr. Taylor over to the shop, the law doesn't require that a suspect be present during a search. It's good practice, but it's not a legal requirement. So ultimately, whether Mr. Taylor was there or not, it did not affect the validity of the search, is what the judge said. Them find the gun there, and it's yours. I'm satisfied, so that I feel sure that the police opened a lock to a secure door to the entrance of the furniture shop, and I accept that Mr. Taylor was there, and that inside the police saw lumber, tools, material consistent with the shop being a furniture shop. I am satisfied so that I feel sure that a firearm was found inside this shop as well. I do not accept the evidence coming from Mr. Taylor and his witness that the shop has multiple entrances, because what would be the point of having a key to unlock a door if there is always open entrances? It makes no sense to me. Absolute nonsense. What's the point of locking a door if there are 5 other places you can enter? Total rubbish. The attorney said. No, not the attorney, the judge said. Now, as to whether the account given by the detective inspector who arrested Taylor was legally sound, the judge said, I am satisfied so that I feel sure that this place doesn't have multiple points of entry and has no other than the door that was unlocked by the police, and that was the shop, the entrance to the shop. Mr. Taylor had control over by virtue of the key that was taken from his home, and this furniture store had a rifle in it hidden behind a stack of boards, and that it had rounds of ammunition and items. That item was taken to the ballistics lab. Based on these evidence, Mr. Taylor is found guilty of possession of an illegal weapon and possession of illegal ammunition. So one bag of ring around in court, but that is how it went. In Taylor trying to mount his defense as to why somebody must have put the rifle there, because me don't know how that AK they end up in my shop. Well, there you have it. He's found guilty. And may I remind you that Taylor, who is the owner of the furniture shop, is also the cousin of Andre Blackman Bryan. So the headline for that would be Andre Blackman Bryan's cousin found guilty as well. Possession of illegal firearm and possession of illegal ammunition. Here's the question though. Of recently, the law changed in Jamaica, and the law says if you are found in possession of an illegal weapon, you are facing a minimum of 15 years. A minimum of 15 years in prison. Mandatory. So, will these guys be given that time, or will they be given the time that was on the books before it was changed? The reason why I ask this is because their case started in court. They were arrested and their case started in court before the law was changed. So, do they fall under the old law, or are they going to be prosecuted using the new law? Leave your comments in the comment section below. I'm still following this Clansman Wanda and gang trial thing, and I will have more updates for you as more information comes out to the public. Shout out to the Jamaica Observer. Thank you for this one, and I'll catch y'all on the next video. It's SouFLoTV. I'm out. Peace.